Your Honor, calling People v. James Crumbley, case number 2279989 FE.
Thank you, Mark Keese, on behalf of the people.
Karen McDonald on behalf of the people.
Good afternoon, Your Honor. Marielle Lehman on behalf of James Crumbley, who is standing to my left.
Good afternoon, Mr. Crumbley. Can you hear us?
Yes, I can. Thank you, Your Honor.
All right. Are you ready for the jury?
Yes.
We are.
Yes,
All
sir.
right. I will bring them in.
All rise for the jury.
Good afternoon. You may be seated. Ladies and gentlemen, the witness testimony and the evidence portion of this trial have been completed. We will now hear the closing arguments. Much like the opening statements, these are not evidence. They're only how each side sees the case. Because the prosecutor has the burden of proof, they also have a right to rebuttal. You also will have a copy of the jury instructions at the end of the trial and when you're deliberating, right? Prosecutor?
Good afternoon. On November 30th of 2021, around 1 o'clock in the afternoon, Lieutenant Tim Willis doesn't remember exactly what happened immediately upon being informed that there's a possible shooter at the Oxford High School. Doesn't really remember who he called or how he got down in the elevator, but he remembers one thing. Whoever he called, the first thing the caller said was, "It's real." Doesn't really remember the details on how he got there that day. But he did tell you that of all the first responder scenes he's ever experienced in his 20 plus years of being in law enforcement, this was the largest and most serious by far, and the second, what didn't even come close. Ed Wagrowski, who is now works for the Secret Service but was worked for the Sheriff's Office in the Computer Crimes Department, told you that he went so fast that he could barely keep his tires on the road. He told you that he will never forget the look on those kids' faces because they looked like zombies. He also told you that in that moment of crisis, he will never forget the looks on the parents' faces who were waiting desperately for their kid to get off those buses. Molly Darnell, a seasoned teacher who had years and years of training on what to do in an active shooter situation, she told you that even though she locked eyes with James Crumbley's son when he fired his SIG 9mm at her and hit her, she still couldn't believe she was shot. She told you that she didn't even put it together when she felt the warmth and burning on her arm. She didn't even trust herself to recognize a voice she'd known for over 20 years outside the door. And you heard from Chrissy Gibson Marshall, an assistant principal who had had hours and hours of training on what to do in an active shooting situation. And what did she do? She ran towards the shooter. She ran towards the shooter. All the training, all the preparation, and she did the opposite of what she was trained to do and what she tells everybody else to do. Because she couldn't believe it. And even when she saw James Crumbley's son with that gun, she still couldn't believe it. But she wasn't going to leave because Tate needed her help. All four of these individuals trained for years and years and years. Law enforcement, what to do in an active shooting situation. Yet, all four of them, as experienced and trained as they were, had no idea how to accept the reality that this was happening. Which is why Lieutenant Willis remembers it's real. Ladies and gentlemen, those four people, they were adults. Those four trained, experienced people were adults. These four were children. And so were the hundreds of kids in that school. What happened that day is about the deaths of these four children and what James Crumbley did and what he didn't do. The shooter has been sentenced and prosecuted and convicted. He pulled the trigger. James Crumbley is not on trial for what his son did. James Crumbley is on trial for what he did and what he didn't do. James Crumbley had a willful disregard of a known danger it caused the death of 4 students in Oxford High School on November 30th, 2021. Hannah, Madison, Tate, and Justin. I'm going to spend a few minutes on the law, but the judge is the authority on what the law is, and she's going to instruct you what the law is. He's charged with 2 counts of involuntary manslaughter under 2 alternative theories. You don't have to find both. You don't have to agree on both. You can agree on both, but either one is the only thing necessary to return a verdict of guilty. The first is that there was gross negligence in the performance of a lawful act, and that the defendant caused death, and in doing the act that caused death, he acted in gross negligence. And then the second is his failure to perform a legal duty, and that he knew about the facts that gave rise to the duty, and he willfully neglected or refused to perform that duty, and he failed to perform it, and it grossly negligent to human life. And that the death of the victims were directly caused by defendant's failure to perform this duty. 4 counts of involuntary manslaughter for children who were killed. There can be more than one cause of death. James Crumbley doesn't get a pass because somebody else also caused the death of these 4 kids. And the judge will instruct you on that. It's not enough that he just made it possible for the deaths of Madison, Tate, Hannah, and Justin. You must find beyond a reasonable doubt that the deaths were the natural or necessary result of his acts or failure to act. You heard the evidence about how each of those kids were killed. And as previously noted, there can be more than one cause of death. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Not that he knew his son was going to kill 4 people. That is not what I have to prove. just that it was reasonably foreseeable. What's gross negligence? It's more than carelessness. It's willfully disregarding the results to others that might follow from an act or failure to act. And in order to find that, you have to find the defendant was grossly negligent, and you must find each of the following three things beyond a reasonable doubt. First, that he knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring someone else. Second, that he could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another one to a reasonable person. A reasonable person. And it must be apparent that the result was likely to be serious injury. In Michigan, a parent has a legal duty to exercise reasonable care to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Even before we had safe storage, there was always a legal duty that existed. That newly passed law has no bearing on your legal duty that, as a parent, that you've always had. I said this before, there are two theories, two different ways to prove the same crime. If proven, one of these, both of them, are sufficient to establish the crime of involuntary manslaughter. And again, it's not necessary that you all agree on which theory has been proven, as long as you agree that the prosecutors proved at least one of those theories beyond a reasonable doubt. I want to stop before I talk about the evidence briefly. I want to note that everyone appreciates how much care and patience you've taken in listening. It's clear and it's obvious, and I thank you for doing that. There are people, though, who think that the prosecutor's job is just to convict people. And that's just not true. It's our job to present you with the facts and tell the truth and to be advocates, and telling the truth sometimes involves showing you things no one wants to see. Sometimes our job requires to produce evidence and testimony and pictures and images that we don't want to show you and no one wants to see them. But that's our job. That's my job. And it's not our job to sanitize, even though that would be easier. It's my job, and it's Mr. Keith's job, to present all the evidence to you and explain why we think the defendant is guilty beyond a reasonable doubt. Mark Keith told you when this trial started that any number of tragically small efforts could have saved the lives of 4 kids. That it was foreseeable and it was preventable. And the evidence presented in the last 5 days has proven that, ladies and gentlemen. James Crumbley was presented with the easiest, most glaring opportunities to prevent the deaths of these 4 students. And he did nothing. He did nothing. He did nothing over and over and over again. And the evidence shows that. This case is not about holding James Crumbley responsible for what his son did. Again, if he knew exactly what his son was going to do, he'd be charged with murder. It's about his legal duty and his failure to perform it, or to perform it in a negligent way. You heard the testimony of Molly Darnell. She told you that the first thing she saw when she looked through the window and saw the gun being raised towards her was that there was no orange tip, which she had learned previously, she doesn't remember where, meant it's a real gun. that he aimed the gun at chest level and he locked eyes with her, and the bullet landed 6 inches from her heart. Ed Wagrowski, who was a member of the computer crimes unit in the Oakland County Sheriff's Office. He told you about what forensic evaluation of cell phone analysis is. He was qualified as an expert. He described his involvement and observations at the school that day. And he told you that he doesn't really respond to incidents like this. He was in computer crimes. No one comes into the office and says you have to respond to a critical incident, except that day. And you could tell that that had a great emotional impact on him. He watched hours and hours and hours of videos and images of that school that day to put together the evidence that we were able to present to you today and through the past 5 days. He reviewed all of it and he described and then showed you the path and the camera angles of the shooter's path through the school that day. He also presented the messages between Jennifer and James Crumbley and the messages between their son and his friend. He told you that there were over 20,000 text messages between the shooter and that one friend he had. He also told you in 1 year there were only 65 text messages sent between James Crumbley and his father. James Crumbley, who had either worked at home, was in between jobs, or had DoorDash. James Crumbley, who was the person he dropped his son at school every single morning. He told you that the image of the gun that the shooter shared with his dad was deleted. We played the voicemail from the school on November 29th from Pam Fine, talking about his son searching bullets. He presented evidence that he was aware of that because Jennifer told him about it. She texted, "Did he tell you about what happened at school?" James responded, "Yes." He shared with you the defendant's communications on November 30th of 2021. And important to note, he was able to show you exactly the path that he took. Because of the cell phone data, some of you were probably surprised and a little concerned about how much somebody can actually know what you're doing, but it's a lot. And we know exactly where he was, what he did, who he talked to, and so we could trace his steps, which turns out to be some of the most critical evidence in this trial. He showed you through the DoorDash search warrant returns the locations of what James Crumbley was doing from the moment he left the school that morning until the moment he called 911. And only after he learned that there was an active shooter at the school did James Crumbley go home and look for the gun. Even though from 11 o'clock to 1 o'clock, he had 4 DoorDash pickups and passed his house many times. He was within minutes, many times. And you heard the 911 call by James Crumbley about 14 minutes after he arrived home and discovered that the gun was missing. Bob could tell us, he testified, and we showed you images of the hallway in that school when he processed the scene. And you saw pictures of that. And he told you that a total of 50 fired and unfired cartridges were recovered. And that the shooter fired 32 rounds and 18 were unfired. And we know where he got those 50. You saw that. It's when he pointed them out across the counter when he's with his mom standing a little bit behind her and said, 2. And you also know that James probably knew that. Because when he was at the substation and they asked about where this gun was, who owns the gun, where's the ammo, he described it as he bought 2 boxes, referring to his son. Bob Catellis told you that those are rods placed in where bullet holes have penetrated that glass. And as you can see, and you saw other images, this was somebody who knew how to use a firearm. And Special Agent Brandon told you that's immediately what he observed. Those are shots, if landing on a human being, would kill them. Cami Batt explained in detail what her requirement is and what she did that day, and that she knew James Crumbley because in June he came in and he bought 2 more guns, one for himself, which the evidence showed, because he told Jennifer how much did your gun cost? It was $300, and then there was another gun, which was his son's, the Derringer, and you saw the Derringer. She told you that she also sold him the 9mm on the 26th, that his son was present with him. He stated he's had his eye on that gun. She told you that they sell a locking mechanism with each gun they sell, that he was provided the trigger lock statement, and that there was a cable lock with the Sig Sauer when he bought it, and it was provided to him, and the ATF pamphlet solely in existence to just warn people, once again, the dangers of firearms with minors. And she told you that regardless of what kind of mechanism they provide, they always provide a tool with anyone who purchases a firearm to make it safe. Sergeant Joe Bryan testified and introduced the video, the recorded statements of James in the substation. James' statements indicate he knew that his son had only one friend and that he left abruptly. He referred to the math worksheet that morning as some doodling on a paper. But that was after the shooting. Before the shooting, we know that he texted Jennifer Crumbley, WTF, when he saw it. Now he's downplaying it. It's just doodling. When asked how many rounds, he corrected Jennifer and indicated there were a box of 50 rounds that he bought his son. When asked where the gun was, James responded, it was hidden in an armoire, in the case, and the bullets were hidden in a completely different spot underneath some jeans. We're going to get to that. What James didn't say that day, no mention of any lock. No mention that the school wanted them to get their son help that day, and then when they couldn't, within 48 hours. And here's something you never hear him say. You hear him say the gun was hidden. You hear him say that there was some doodling on a paper, that he was a perfect kid. But here's what he never says. He never says, I don't know how he got it. Never said that. He never says, it was hidden. I have no idea. I can't imagine how he got a hold of this gun. Never mentions that. 4 kids just died. Your son's in custody because he committed a school shooting, and not once do you say, how did he get the gun? And you know why he didn't say it? He didn't say it because he already knew. He knew his son had access to the gun. Christy Gibson Marshall, as we just talked about, heard gunshots, saw kids running in a way that wasn't normal, went towards the shooting, identified and spoke to James Crumbley's son, and you saw that video, how she just stood there. Sean Hopkins. Sean Hopkins was a counselor. He testified that the shooter was looking up bullets the day before. He was aware of that. That morning he was told he was watching violent videos. And he told you that even in a 20-minute period of time, he was concerned enough to call parents and ask them to come to school right then. He told you that he said he needed help right away. He wanted them to get him some help right away. He told you that he was very concerned about the images, but his main concern was for the safety of the shooter. He told you he didn't want him to be left alone. And he said in that meeting, he never received relevant information from mom and dad. It was short. It was a very, very small period of time for a meeting that takes place when you have to come from your work. James was at the barn at the time. Go to your son's school. They were in and out of there in a very short period of time. He testified, they said that just couldn't happen today. They had to work. Now, you've heard the testimony. You know what James Crumbley was doing as employment during that time. And defense counsel and I agree. That is a worthy endeavor, being employed regardless of how you choose to do it. But what's important to note is that DoorDash is not something that you can create your own hours. You can work when you want. It's not compulsory. You can work on the weekends. You can work anytime. Nick Ejak is the Dean of Students, testified that he was also at the meeting and that James Crumbley seemed irritated. And that at the time they knew only a fraction of what was going on. No one told anybody at the school. They just purchased him a gun. Neither one of them. James Crumbley didn't say, you know what, we had this fight before. They mentioned about the fight the night before about grades, but didn't really discuss it as a big deal. Didn't really discuss the gravity of what it was like for his son, who had one social connection to the outside world, and that person abruptly left with, and that his son found out because he just stopped texting him back. And that he was obviously so concerned and upset that he communicated that to his father because his father reached out to the friend's father. He didn't say that. He didn't say that the weapon wasn't secure. He didn't say that there had been signs that something wasn't right. Now, you may not like what the two people who were employed by the school and had contact with the Crumbleys that day did. You may not like it. I don't like all of it either. But my job isn't to present to you the evidence that just looks good for my case. My job is to present evidence to you, all of it, because this is about the truth. But he doesn't get a pass because you don't think the teachers did enough. He doesn't get a pass for that. And the blame shifting is only meant to send a message, I'm not accountable here at all. Even though I bought the weapon. Even though I didn't secure it. Even though I never got help from my son. Even though I could have taken him that day. Special Agent Brandon testified where he was when he heard about the shooting, what he did when he got to the school, how he traced the gun, how he found out who owned it. He watched the surveillance. He noticed a couple things that were really concerning to him. One, it was somebody that was proficient with a firearm. He did what's called a combat load, which is unusual. The way his stance was, the shot he took that killed Tate. This wasn't somebody that wasn't experienced with a firearm. And logically, he wanted to know where this person was taught how to handle that weapon, where that minor was taught, that 15-year-old. And he discovered that. He testified that the cable lock that was seen in pictures was sold with the SIG, and it was the cable lock that was seen in the photos. And then he testified that they found that cable lock shoved in another gun box in the kitchen in a cabinet behind a door. You also heard him tell you that the minute he looked at that drawing, he instantly noticed the gun. It wasn't just any old gun. It wasn't. And maybe you wouldn't have picked that up. But Special Agent Brandon did. And you know what? Who else would have known? The person that purchased the gun, James Crumbley. Detective Stoyak talked to you about the search. You saw pictures of the search and the house. You saw where the gun box and the ammo box were when they searched the house. It was on their bed. You also saw a map and learned a pretty small house. Pretty small. You learned he had 2 bedrooms. And you learned that in that master bedroom, which was small, there was the bed, some nightstands, and 2 other pieces of furniture. The TV stand, where he found the 2 other weapons that were in a gun safe, a locking mechanism, with the code set to 000, which is the default. Detective Stoyak and told you what others did. He never, ever, ever said that that SIG was locked. He said it was hidden. David Hendrick is in charge of the fugitive apprehension team. You learned what that is from 2 law enforcement officials. You learned that on the day the defendants were charged, they left a hotel in Auburn Hills, local, and drove all the way to Detroit in a building that is meant for businesses, not retail. People don't sleep there. And you heard what it was like when he arrived on the scene, when they were searching for James Crumbley and his wife. You heard through the body cam of the Detroit officer, and you heard from Officer Hendrick, and you heard from Luke Kirtley that it was extremely loud. There were dozens and dozens and dozens of law enforcement, and most of them SWAT. Luke Kirtley told you about how James Crumbley was discovered that night. And the only reason he knew it is because it was all over social media with the description, the license plate, and a picture of James Crumbley and Jennifer Crumbley. Why? Because they were charged. And even before they were charged, there was a lot of speculation about them being charged. Luke told you about what that building looks like, what it's for, who's normally there at night, not many people, that he shares a wall with that studio that they were found in, that that mattress they pulled in was out in the hallway. He again told you how loud, and that it would have been impossible if he was in his unit not to hear that. Officer David Metzke told you that there were tons of officers, multiple agencies, and that they took a 35-pound steel ram to bypass multiple doors, and they used it, and it was loud. I think he testified we have the bigger guys do that. We saw through his body-worn camera the arrest of James Crumbley, who was laying on the mattress and seemed to be wanting to create the impression that he was sleeping. There's a big problem with that. One, we know that shortly after Luke Kirtley went out to see the license plate, that he followed him shortly after, and he was awake. And shortly after that, dozens and dozens and dozens of law enforcement show up on the scene. It's a first floor unit. The windows face that parking lot. Lights and sirens, media were there, yet he's lying on a bed as if he's sleeping. William Creer told you what they discovered. They had bought and purchased, they had purchased items with them, socks, new socks. They had clothing, they had food, there was a whiskey bottle in the trash can, there was ice. But here's the thing that was the most compelling about his testimony. The bag with the 4 phones that were turned off and $6,000 of cash was stored on the other side of the room from the backpack in a lid in a plastic bin with a lid on it. That is strong circumstantial evidence, which is used in this country every day to convict people, that was placed there in hopes that no one was going to find it. $6,000 cash, 4 cell phones turned off, which is odd if you're really trying to get up in the morning and go somewhere, and the alarm was set on one of those phones, but they were off. But what did Ed Wagrowski tell you? He told you that you can't track a phone if it's off. You can't track it. We all learned, if you've learned nothing else, turn your phone off if you don't want to be tracked, because there's all sorts of ways. Lieutenant Willis testified. He showed you the bank records showing what they did when they found out that their son was charged and when there was talk of them being charged. He talked to you about the scene at Oxford High School. And it was a really detailed description of what it was like in that school that day. Because hundreds and hundreds of law enforcement officials went to that school, some miles away. No one asked them to. They just drove there from all different parts. And so it was Tim Willis's job to take all of those people who wanted to help and give them something to do and get the scene processed and start building a case. And answering questions, which is really what an investigation is about, way before you get to a prosecutor. Because sometimes you never get to the prosecutor. Your job is to go where the evidence leads you. And there were things about this case from the very beginning that just seemed like questions that needed to be answered. And one of them was, that gun was purchased 4 days earlier by James Crumbley, who was the same person who was at the school that day. This is information they're learning immediately. They do a search warrant for the house and for phones, and they find out a lot of information. You saw the video of the shooting. There's a reason we tell the media they have to turn their cameras off. We don't want those images out there. We don't want them to be on the internet. We don't want to encourage another school shooter. And we don't take any pleasure in showing it to you. But it's our job to know the truth and look at it and not look away. He told you how each of those kids died. Hannah was hit immediately after he left the bathroom. You saw the image and it was described to you. Madison Baldwin didn't run. She crouched down. There was a door 4 feet from her. And she put her hands over her head. And he walked right up to her and he shot her at close range in the head. Tate was shot. I talked about that shot he took as he was coming in the door. He had his headphones on. He didn't even know what was going on. And Justin Schilling was shot in the bathroom after several minutes of being in there. It wasn't immediately. She went into the bathroom, stayed there. Justin knew the shooter was there. And there was another student in there as well. You saw him running, Keegan. And he ran after James Crumbley's son shot Justin Schilling, execution style. Defendant's son had access to and the use of this gun. It was preventable and it was foreseeable. You heard during jury selection, and you heard during opening, and if my prediction is you're going to hear it again, that this could be you. This could be any of us. This is what defense, this is their defense, that this could be you if you let your kid drive a car or leave with a sharp object. This couldn't be everybody. This couldn't be the person that takes their kid hunting. This couldn't be the person that buys a gun for their child to use, for their minor child, for their use. That doesn't create a criminal charge, ladies and gentlemen. It couldn't happen simply because you purchased a firearm or simply because you let your kid drive a car. Beware of the claim that this could be you. Beware. It is not the case that finding James Crumbley guilty of gross negligence would result in a criminal charge for every parent who doesn't know what their child is doing at all times. And it is not the case that he was faced with the same normal challenges as parents that we all go through and suddenly found himself in a courtroom being charged with involuntary manslaughter. It is just not the case, and the evidence shows it. In June, the Derringer and the Caltech were purchased by James Crumbley. We know that Caltech was left out, unsecured, with ammo. Why do we know that? You saw that picture and video and the one he sent to his friend, and you saw the text that accompanied. But before we get to that, this is an image from the video that you saw. It was 12:30 at night. That is his cat, Dexter. That is the shooter's cat. That magazine is loaded, and it was shoved on a table to load it, not a proper or safe way to handle a firearm. And there is a round in the chamber, and the safety is off because red means dead. And Special Agent Brandon told you that. Even if James Crumbley was standing next to his son, that would still be an extremely dangerous way to handle a firearm. But we do know what happened, because he told his friend when he texted it to him. My dad left it out, so I thought, why not? This is precisely the reason there's a legal duty in the state of Michigan to prevent your kid from harming himself or somebody else. All I need is my 9mm pistol, which I currently am begging my dad for. This is from his journal. First off, I got my gun. It's a Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I have access to the gun and the ammo. Then we have defendant's own statements. James Crumbley said it's a substation. James responded when it asked where the gun was. It was hidden in our armoire in the case, and the bullets were hidden in a completely different spot underneath some jeans. Here's what he doesn't say. Never claims it was locked, never says it was inaccessible to his son, and again, never says or expresses any surprise on how his son got a hold of it. We know he took him to the range. We showed you videos and images of that. In fact, 8 times we know that happened. We know that throughout June, July, August, September, October, by November, when he begged his dad for the 9mm, and he actually did buy it for him, Now he's at the point where he can instruct other people. It's James Crumbley's son that knows more about guns and when he takes his mom to the range. And how did he learn? James Crumbley taught him. He didn't take himself to the range with his dad. This is the shooter 2 days, 1 day after the gun was purchased for him. He's packing it up. What don't you see? The cable lock. It's not even in a case anymore. And there it is. That's the cable lock that was provided that day with the pamphlet and with the gun. Just the day before. It's already out of the case. Here's where the other 2 guns were found in that bedroom, in defendant's bedroom, in a safe. In the TV stand. The code was 000. The important thing is that the SIG could not fit into that gun safe. Could not fit it. It's impossible. But the other important thing is you're hearing a claim that James Crumbley didn't think that he had to lock his weapon up. Okay. It's not about whether you locked the weapon. It's about whether you made it secure. And we already know he felt the need and understood his duty to lock the other 2. Special Agent Brandon read to you the lines if he had opened it up, if he had read it, if he had believed it, those deaths could have been prevented. If he had just read it and just did the simplest of things. This is the crime scene. There were 32 shots fired that day by James Crumbley's son. How do we know this was foreseeable? The shooter says in his journal, "I have zero help for my mental problems, and it's causing me to shoot up the fucking school." You heard a lot during jury selection and opening about kids exaggerate to their friends. This is his journal. He's not sending it to a friend. He's expressing his state, which was desperate because he needed help. I want help, but my parents don't listen to me, so I can't get any help. My parents won't listen to me about help or a therapist. I can't even say with a straight face or even find a way to explain the rationale behind a 15-year-old that desperate writing that in a journal because he was exaggerating or lying. We have the text between James Crumbley's son and his friend about exactly what he wrote about in the journal. He hears people talking to someone in the distance. I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up. Again, teenagers exaggerating to make themselves look better, to impress. None of these text messages to his friend make him look better. None of them make him look impressive. They just make him look desperate and sad and wanting help. I'm having bad insomnia and paranoia. I need help. I was thinking I could call 911 so I could go to the hospital. This was in April. But then my parents would be really pissed. I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. But this time I'm going to tell them about the voices. And then on April 5th, like I am mentally and physically dying. What did James Crumbley know? He knew the family dog had died. A grandmother had just died. His son's only friend, the one person he had any social contact with, abruptly leaving, can't even text him. Knew his son was completely isolated. Knew he had looked up bullets the day before. Knew he was upset the night before. Knew he had been watching videos that morning, violent videos. And then he sees that drawing. He sees that drawing that morning when he goes to the school, and what does it say? It says, "Help me." How many times does this kid have to say it? He says it in his journal, he says it to his friend, and what is he saying? I asked my parents, I asked my dad. And then if that isn't enough, he writes the words, "Help me," on a piece of paper. And his parents, James Crumbley, is called to the school to see it. And what does he say? He says, "We gotta go to work." He describes his son as a perfect kid, never gets in trouble. Well, you know, if you have a perfect kid that never gets in trouble, being called to the school abruptly that day and asked to come and saying your kid needs help is about 100 out of a 10 in terms of how troubling it is for a parent, if it's that unusual. He knows his son is proficient with guns because 4 days earlier he purchased that weapon for him. This is James Crumbley's son on the morning of the shooting, November 30th, being dropped off, like every day, by James Crumbley. And here's the worksheet. The thoughts won't stop. Help me. You have a picture of someone bleeding with bullet holes. You have a picture of the exact gun. It says blood everywhere. My life is useless. The world is dead. This is the worksheet James Crumbley looked at when it was texted to him. This is the worksheet he sat and looked at when he sat in that counselor's office. Those are the words he was reading when his wife said, "We can't do that today. We have to work." And he said nothing. And he leaves with a piece of paper with the names to call. This is what he was looking at. And there's the piece of paper. It took just one tragically small measure of ordinary care to avoid 4 deaths. James Crumbley failed to use ordinary care, which could have prevented the death of these 4 kids. Didn't stop at home to check to see where that gun was. Even though you can't take him, which we know he could have driven around with him. He could have not done any DoorDash round until Jennifer comes back from work. He could have gone to see where that gun was. We know that in his DoorDashing, he was minutes away from 11 o'clock to 1 o'clock. He didn't search or ask to see the backpack, never thought then to say, "Hey, can I talk to you out in the hall?" or "Hey, where's that gun?" Didn't ask his son where that gun was, didn't check the journal, despite acknowledging he had one, didn't lock and secure ammunition, didn't lock or secure the gun, didn't take his son home, didn't take him to get this care that a counselor's telling you he needs, didn't say, "We bought him a gun 4 days ago as an early Christmas present," and didn't tell the school much relevant information at all, and Sean Hopkins told you that. He also didn't disclose any of the instances that you were shown throughout this trial. That there was a message in March about him doing something stupid. Jennifer Crumbley was concerned about it. James was always home. Is he home yet? Is he home yet? Is he home yet? Leave me alone, I have to work. He's fine, is what he says. The incident about giving him melatonin and him being worked up, didn't tell him that he'd asked him for help and asked to go to the doctor, told him to suck it up. Didn't say about the friend and how it was his only person he ever had any social contact with, that there were multiple guns in the home, that he was begging for a 9mm. James Crumbley never even shot that gun. He didn't fire it once. He had it, he purchased it on Friday. On Saturday, he was gone all day doing DoorDash. On Sunday, he was gone all day doing DoorDash. in that he wants you to believe he had this secure hiding spot. What, it was a hiding spot for one day? We know it wasn't there on Saturday. We have the shooter taking pictures of it. And we know the cable lock isn't around. And we know Jennifer leaves. He's alone with this gun. Didn't say that it was identical to the one in the drawing. Didn't say he bought 50 rounds to take home. Expensive rounds to use at a range. This is the DoorDash information from 11 o'clock to 1 o'clock and all of the times he passed that house. He was within minutes. We know that he was absolutely concerned about this worksheet until after the shooting in the substation where he says it was doodling. We also know that not once on any of his devices did we find any searches or information he was trying to get about firearm safety or how to make sure a minor doesn't get a hold of it, laws, any of it, until after the shooting. We know that at 10:37 he arrives at school. His son leaves at 10:52. They're gone by 10:53. At 11, he logs on to DoorDash. He completes 4 orders. He tells us in the 911 call and at the substation, he saw cop cars. We know that 12:51, the shooting starts, and we start to see students and parents, we heard, arrive at the Meijer. They're being told by dispatch that's where their unification time is. James drops off his last order at 1:01. The email comes out from the school at 1:09. At 1:11, James is in the Meijer parking lot. It's unclear exactly why. He calls his wife for 57 seconds. That's the call lasts 57 seconds. He's on the phone with her for 10 minutes and 19 seconds. He gets home at 1:20. During that call, she texts her boss, the gun is gone and so are the bullets. So we know that by 1:23, both of them had knowledge about that. He calls her again, 1:30 to 1:33, another 3 minutes, and finally calls 911 at 1:34. There were 1,800 students in Oxford High School. There was one parent who suspected their son was the school shooter, and it was James Crumbley. You know what that's called? It's called foreseeability. That's what that's called.
What's the location of your emergency?
Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to the high school. I have a missing gun at my house. I need an officer to come to my house right away, please.
Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation right now.
I understand that. There's a million cops there. I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper, and then I was in down, and I saw a whole bunch of cops going somewhere, and I wasn't sure, but I wanted to get to the hospital, see someone going to the high school, and then somebody told me that there was an active shooter, and then I raced home just to find out. Okay, and I think my son took the gun. I don't know if it's him. I don't know what's going on. I'm really freaking out. My son's name is Ethan Crumbley. Crumbley.
C-W-Y. All right, sir, I'm going to put you on hold for just 1 second, okay? I have to talk to Cookman. Come in and see if I can do anything for you, okay? I'm going to put you on hold.
Thank you.
Okay, then.
You just heard this. I have a missing gun. My son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper. And then I saw cops going somewhere. I wanted to go to the school, see what was going on. I heard about the active shooter, and I raced home just to find out. We don't have to discover or argue about whether or not he was put on notice that something was really, really wrong. He says it. He says it. He calls and he says, because of this meeting at the school, and because I have a gun, I went home to look for it when he heard about the shooting. So the question of whether or not that did concern him, it's not a question. We know it concerned him because he said it. And then at the substation, and this is what he says, and somebody said there was an active shooter, I immediately freaked out because the situation. And after I saw all the cops, after I found it was an active shooter that went on this morning, and after what went on this morning, what's he talking about? He's talking about the meeting and the words on the paper. It says, help me, blood everywhere, with a picture of the gun he bought him. So I raced home and I found the gun missing. We went into detail about what James Crumbley and his wife did after they thought they might be charged with a crime. And the evidence clearly shows what they didn't do. They did not turn themselves in. They did not make sure that they were in the area. They withdrew $6,000 and they went to Detroit and turned the car around so the license plate is not facing, and didn't go out and buy that stuff themselves. They sent somebody else. And lastly, defendant conflicts his own statements. At the substation, the drawing was doodling. When he receives it from his wife, he's concerned, my God, WTF. He says at the substation, I immediately raced home and found the gun, and that's when I called you. I called you guys right away. It was 14 minutes after he got home. You think your kid has this gun, you know he does. You know he's really upset, you know the words he wrote, you suspect he's the shooter, and you wait 14 minutes to call 911? He doesn't know when the shooting started or when it ended. I think he owed something to the parents and the kids in that school to at least try, once he did figure out that the gun was gone, which any reasonable person would have known. But why lie and say you call right away? You called after a 10-minute conversation with your wife. At the substation, he's a perfect kid, doesn't get into trouble, yet he was looking up bullets, and yet they were called to the school, and the drawing, he doesn't say that, or what the drawing was really about. It's a downplaying situation, and then he says the gun was hidden. And again, never once, I don't know how he got it. Never once says that. James Crumbley had concerns that day. He knew something was wrong. He said it in his own words. And we know that because of what was on the drawing, and we know that because we know what his response was when he received the drawing. He kept those concerns private that morning. But he didn't just fail to inform the school. He failed to act. James Crumbley failed his son in a tragic way. You're not going to hear me say that's not true. But he didn't just fail his son. He failed Hannah. He failed Madison. He failed Tate. And he failed Justin. He failed to perform his legal duty to prevent these kids from being killed. And he failed their parents, too. And I ask that you find him guilty. Thank you.
Thank you, Prosecutor. Ms. Lehman?
Yes, Your Honor. There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings in particular have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James Crumbley and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that that day had on them. Multiple people told you what that day was like. They told you what they felt, they told you what they saw, and they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hannah St. Juliana, Madison Baldwin, Tate Meir, and Justin Schilling. As you've seen throughout this trial, the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others, and that James acted in a grossly negligent manner or breached a duty that he owed to other people, despite having no information at the time. You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021, and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, if there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. when it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence, a little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have 1 or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty. You can believe that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't. Because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt. Also, if James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that, but you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon. Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission, the prosecution would have shown you that. But you didn't see it because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've seen him. Judge Matthews instructed you at the beginning, James is wearing headphones. James is hard of hearing. He needs a hearing-assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
Your Honor, I hate objecting in a closing, but that is not evidence, and her client didn't testify, and so it's just not evidence what he was doing, and it's just not, and his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the time that his son made that video. He knew that James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyak told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm. Was it unsupervised? We don't know. Was it supervised? We don't know. We don't know. So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time. Instead, you saw texts between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw them, saw James and his son, and saw no concerns. Not worried, didn't hear anything, didn't see anything, wasn't made aware of anything, no concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation that he had talked to his son that morning, told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son, right in front of Sean Hopkins' desk. Sat next to him, went over the piece of the math assignment with him, the drawings, what was on there, that he was caring, that he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication at all, just that one may exist. And again, in that meeting, there were no comments, whether either before James got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me and I need you to tell them. That didn't happen. Instead, Mr. Hopkins testified that he had concerns about the level of although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he'd had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework while sitting in the office waiting for his parents. He asked for them to go get his homework. So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed one or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself more than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, my son was a great kid. I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that. But Christy Gibson Marshall also said that James's son was a good kid. Christy said that her testimony was that she was standing in the hallway. She had spotted the shooter coming down the hall with a firearm, with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand and an injured student in front of her, smelling cap gun, she didn't think that was right. Even in those moments. Going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they didn't believe that, or they believed that James and his wife were going to get their son help. That they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't. Sean Hopkins and Nick Ejak testified that they didn't ask if there were guns in the home. They didn't ask because they weren't concerned that James's son was a danger to anyone. Despite the information and the concerns that they had, they made decisions with the information that they had at the time and based on their education and training, which we can all probably agree a school counselor and a dean of students has more education and training than the average parent. And even with all of that and the experience with teenagers and what they had in front of him, they still didn't believe that there was a reason to be concerned that James's son was a danger to anyone. In fact, they didn't even feel that he was an immediate danger to himself, because if they had, they testified, they would have done things differently. James worked. You heard the testimony. He left the school at approximately 10:57, and if you want, you can go back to the exhibits, and logged on to the app for DoorDash and started working within 3 minutes. The prosecution is focusing on James not going home in the time from leaving the school and when the shooting started. Why would he? He didn't know. He didn't know what was going on with his son. He didn't know what his son was planning. He didn't know that his son knew where the guns were. And he didn't know that his son had somehow obtained access to those guns, or a gun. He didn't know. So why would he go home? There was no reason to. You heard about James's actions following learning of the school shooting, or following the school shooting. You heard that he went to the Meijer, which was the reunification point on Ray Road. You heard that he saw the police lights, he saw multiple police cars, he followed them. He actually tried to go to the high school first and he couldn't, so he went to the Meijer. And it was there that he learned that there was a shooting at the school, that there was an active shooter at the school. There's evidence and exhibits showing James's movements while at the Meijer. He was there for approximately 6 to 7 minutes. In that time, he texted his son. You can see that on exhibit 375. He called his son to see if his son was okay. He texted his son again. He called his wife. He talked to his wife for about a minute, and he left the school. Then he called his son 2 more times. 2 more times in less than a minute to find out if his son was okay. He talked to his wife again for about 10 minutes. You saw a text during that phone call from James's wife to one of her coworkers where she says that their son was the school shooter. Contrary to Detective Lieutenant Willis's testimony that James said his son was the school shooter, he didn't. James didn't say that. You heard the 911 call a few minutes ago. That's not what James said. James called 911 at 1:34 p.m. and said that his son was a student at Oxford High School, and that after he'd learned about the school shooting, that James had gone home, he found the gun and bullets missing. He didn't know if his son took it, that he didn't know if it was him. And if you recall, Nick Ejak and Sean Hopkins both testified that even during the shooting at the school, even after the meeting that morning with James's son and James and his wife, even in those moments, they did not suspect that James's son was the school shooter. Sean Hopkins testified that he didn't even think that it was James's son who was the school shooter until after he checked attendance, after the shooting had ended, and after James's son had been arrested. You heard James say on the 911 call that he was really freaking out. You've heard that a couple of times from James. And you can listen to that call yourself. It's exhibit 154. You can almost hear, as James is talking to the dispatcher, how he's looking back at what had happened that morning and trying to piece things together and figure out what's going on. You heard from James 2 more times within hours of the shooting at Oxford High School, once at the substation and once while in the backseat of a patrol car. At the substation, James learned that his son was the school shooter, that he was not injured or anything, that he was in fact the school shooter. You heard James say he was freaking out. He asked for a water. His mouth was dry. He was freaking out. James was emotional. I believe that Detective Sergeant Bryan testified that James was sobbing, that he was crying. You can watch it. You can see how James was reacting in that interview. Detective Bryan said that James was forthcoming, that he was willing to speak with them, even after James's wife suggested, maybe we should get a lawyer. Maybe we should stop talking. James said, no. Let's keep talking. I want to keep talking. It's okay. We can keep talking. And he does. He told the police how many guns were in the home, where they were located, that the handgun that was used by James's son in the shooting was a 9mm Sig Sauer. He mispronounced it. We've all heard that. That it was hidden in an armoire. No one in that interview, neither of those 2 law enforcement officers in that interview said, well, you shouldn't have had it there. Was it locked? How did your son get it? You didn't hear those questions. You heard James tell the police that the handgun was stored unloaded and that the ammunition was stored somewhere else. It was stored separately, under some jeans. Again, those 2 officers didn't say, well, you shouldn't have done that. That wasn't right. Well, you did that the wrong way. Well, that was really irresponsible of you, Mr. Crumbley. They didn't say any of that. The police didn't ask if the gun was locked or in a safe. James clearly told them that that 9mm was hidden. And the police moved on. James talked about what a great kid his son was, about his mediocre grades, but overall he didn't get in any trouble. You watched as James saw his son for the first time after that school shooting. It was a very brief encounter. And you saw as James was leaving that he repeatedly told his son he loved him. Ladies and gentlemen, you can watch that for yourself. It is Exhibit 301. He repeatedly told his son he loved him. And then after, as he walks back into the first interview room, you can hear him audibly crying, sobbing at what was going on. And what does he say? He asks the police if he can find out where his son is going to be. And they say, yes, the court will tell you. In that interview, you also heard James Crumbley say, I wish we had taken him home. In hindsight, looking back, I wish we had taken him home. James had no knowledge that his son had access to any of the handguns in the home. You saw his son's own words sometime after November 27th of 2021 and before November 30th of 2021. And we know that because in Exhibit 359 on page 22, his son specifically writes 9mm. And we know that there was no 9mm in that home prior to November 26th of 2021. We know that James's son went to the shooting range on November 27th of 2021 with his mom. So we know that that had to have been written sometime between November 27th and November 30th of 2021. We talked quite a bit about this during jury selection. Most, if not all of you, agreed that there's a difference between having access and giving access. We talked about car examples. We talked about the responsibility in different scenarios, a parent's responsibility in different scenarios. This case is like the first car scenario, where the child takes the car without the parents knowing, takes it out and something happens. This is the first scenario. This isn't the second scenario, where the parents might have suspected that their child might do something. This wasn't the third scenario, where James knew his son was going to do something and just handed him whatever it was he was going to do it with and said, here, take it. This is the first scenario, where James Crumbley had no idea what his son was capable of. He had no idea what his son was planning, and he had absolutely no idea that his son had access to those firearms. Also, as an aside, if it really were his son's gun, why was it hidden in James's bedroom? If it really were, why was it hidden? Not only in the bedroom, but in a location that James's son was not aware of. Sometime before November 26th of 2021, James's son wrote this in that journal notebook that was found. Exhibit 359, page 15. We know that it was before November 26th of 2021 because of some of the other statements that are around that journal entry, which you can look at if you'd like, but they reference a 9mm and a .22 caliber. And we know that there was not a 9mm in the house before November 26th of 2021. And even here, I don't know where my dad hid it, is a reference to .22 Caltech. Even before November 26th of 2021, well before November 30th of 2021, James Crumbley's son didn't know where those firearms were. He told you he didn't, in his own words, in his own handwriting, which was verified by law enforcement. There's no evidence that James Crumbley had reason to believe his son would hurt anybody. I went over this a few minutes ago. Christy Gibson Marshall's testimony was that she had known James Crumbley and his son since approximately 4th grade. She told a story about James emailing her and asking about getting his son's report card or grades or something along those lines, and she responded and said, "Give him a hug for me." She testified about everything she saw, heard, and felt on November 30th of 2021. And as I said, she talked about seeing the shooter walking toward her with a gun in their hand. That as the shooter got closer, she recognized that it was James's son. And in those moments, she thought to herself, this can't be right. He's always been such a sweet kid. She was in such disbelief that was his son that she even tried to talk to him. As he's walking through the school with a firearm in his hand, she is trying to talk to him because she just can't believe that James's son was the shooter. And it was when he wouldn't respond that she realized it must be him. ATF agent Brandon testified there were no laws governing the storage of firearms. We went over this a little while ago. We talked about the various ways that you can store firearms. I outlined a few of them. He testified that people store firearms unloaded and unlocked, which in and of itself is not irresponsible or dangerous in 2021. Not putting a gun in a safe or using a trigger lock alone does not mean that that person is irresponsible. Now, ATF agent Brandon gave you his opinion about what he saw on that math homework. That opinion was given within the last couple of days. And with all due respect to Agent Brandon, his opinion on what he saw is irrelevant. It doesn't matter in this case. What matters in this case is what people thought that math homework showed on November 30th of 2021. And those people weren't concerned. They didn't see what Agent Brandon saw. They saw images that weren't concerning, that are common, that other kids write and draw about. The concern was that he was sad and needed to talk to someone. On November 26th of 2021, we saw evidence and heard testimony that James Crumbley went and bought the Sig Sauer at the gun store. James had been to that gun store on multiple occasions. We heard that testimony from Miss Back, who told you that she recognized him because he'd been there before. There were at least 2 other handgun purchases from that store, which we heard about, the .22 Derringer and the .22 Caltech. James indicated, per Miss Back, that he'd been looking at the Sig Sauer for a few days, or a while. She couldn't really remember which one it was. She testified to both. That he knew that that was the one he wanted to purchase. So he did. You also heard Agent Brandon testify about the cable lock that was found in that Sig Sauer gun case. That the sleeve that the cable lock came in was essentially in pristine condition, that the keys were still inside the lock. Now, if you recall, that Sig Sauer was used. James bought that used. That sleeve being in pristine condition means that the person before him didn't use it either. You also heard that James did not purchase ammunition on November 26th of 2021 or at any point prior to November 30th of 2021 for that 9mm. There were purchases for ammunition when he would go to the gun range for the 22s, but James didn't purchase 9mm ammunition before November 30th of 2021. Cammie Back told you that she had, that James didn't even talk to his son while they were standing there in the gun store. She didn't see any of that. She had no reason to believe that James was buying that gun for anyone but himself. And if she had, she couldn't have sold it. So obviously she didn't think that. On November 3rd of 2021, James Crumbley and his wife left a hotel that they had been staying in. Well, they had stayed in a couple different hotels, but they left a hotel that they had stayed in after the shooting on November 30th. You heard some testimony, or you heard some information that their residence had been made public, or there was media there, or there were things going on, and you can imagine. I mean, you all can imagine what that was like in the days following the shooting at Oxford High School. You heard Agent Brandon testify today that James and his wife were in and out of that building throughout the day on December 3rd of 2021. You heard testimony yesterday from Detective Willis that they arrived at approximately 11 a.m. and that they were there for the day. They were obviously arrested later that night. But you heard testimony that Luke Kirtley saw at least James Crumbley. You heard that James and Jennifer had both gone in and out of the building. Jennifer is his wife, had both gone in and out of the building throughout the day, various times, to smoke, walk out to the car. Sometimes one of them went, sometimes both of them went. December 3rd, 2021 was a Friday. It was a work day. They were in and out. You heard that there were at least 14 cigarette butts found near their vehicle. You saw over 300 exhibits during this trial. You heard testimony from over a dozen witnesses. None of them told you that James knew what his son was planning. None of them told you that James knew that his son was a danger to anyone. None of them told you that James knew that his son knew where those firearms were hidden. None of them told you that James knew that his son had somehow obtained access to the firearms that he had been hiding. None of them told you that, because on November 30th of 2021, James Crumbley had no knowledge about any of that. He had no knowledge, and he had no reason to suspect what his son was planning to do later that morning on November 30th of 2021. Now, every time I do a trial, I have somebody tell me that they think of a reasonable doubt that I may not have thought of. So think of your own. You don't have to agree with all of mine. You don't have to agree with any of mine. You can come up with your own reasonable doubt. Based on the evidence that you've seen, the testimony that you've heard, your collective memories, you can come up with your own. You're not limited to what I've come up with, and you can certainly reach your own reasonable doubt conclusions on your own. And as you deliberate, think about the things you did not hear during this trial. Think about the things that you were told you would hear during the opening statements, that you would hear how the shooter gained access to that gun. You didn't hear that. That you will hear from school officials regarding their concerns about the math worksheet. You heard that they were concerned about sadness, not about danger to others. That you will hear that the need for immediate parental intervention was necessary. You didn't hear that. In fact, you heard the opposite. You heard that Sean Hopkins said that James and his wife, that they wanted James and his wife to have their son talk to someone, or to at least make arrangements within 48 hours. No one testified that immediate parental intervention was necessary on November 30th of 2021 during the meeting with Sean Hopkins and Nick Ejak. No one testified that there was a need for immediate intervention of any kind: discipline, mental health, or otherwise. You did not hear testimony detailing how the shooter obtained access to the Sig Sauer. You just saw in his journal that he said he had access, but you don't know how that happened. No one testified that the shooter knew that there was any sort of code to open the gun safe. There's been some talk about the code that was used on the gun safe with the Kel-Tec and the Sig Sauer. There was no testimony that the shooter even knew about that code or what it was. You did not hear any mutual concern for the shooter's well-being from his best friend's dad, who you saw text with between James and his friend's dad, who obviously has experience with mental health with his own child, from what you can see in the texts. And even that man didn't express any concern for James's son. In fact, on November 30th of 2021, he texted James, said, "I hope everyone's okay." No one told you that James Crumbley was aware of the texts or videos that were sent to his son's friend. In fact, they all testified, all of the witnesses testified they couldn't tell you that. They couldn't tell you that he was aware. You don't know if the shooter ever actually did do what he told his friend he was going to do. He was going to tell his parents about this, that, and the other. You heard no evidence that he actually did. You heard no evidence that he actually told James any of that. And when you go back for deliberations, think about everything that James Crumbley did not know. He did not know he had to protect others from his son. He did not know he wasn't exercising ordinary care in the way he was storing his firearm because he didn't know that his son was planning what he was planning. He did not know that it was reasonably foreseeable that his son would commit these offenses. He had taught his son firearm safety. He had taught his son to be familiar with those firearms because they were in the house. He had no idea what his son was planning to do. In fact, no one that interacted with James Crumbley's son on November 30th of 2021 knew what was going to happen a short time later. No one. And this is the part of the trial that I dislike the most. The prosecution gets to stand up and make a rebuttal statement, and I have to sit down, and I don't get an opportunity to respond. That's how trial rules work. The court has told you that. That's just how it works. But the hard part for me is that every time I hear a rebuttal from the prosecution, I think of all these things that I want to say. I think of all these responses that I can give. So what I'm going to ask you to do, we've gotten to know each other over the last couple of weeks. You've seen how I am in court. You've heard the questions that I ask. So when you go back to deliberate, think to yourselves, what would Marielle say? What would she say about this? What would she say about that? Because unfortunately, I can't tell you. I join with the prosecution in thanking you all for the time and attention that you've paid to this case. You have heard some of the most emotional testimony and seen some of the most difficult things that I can imagine a juror could see. And you likely may not be able to forget it. But what you're all doing in these chairs is of the utmost importance. And I thank you for the time and attention that you've paid. Early on in this case, during our opening statements, the prosecution and I both asked you to follow the law. And I'm going to ask you again. Follow the law. The judge will instruct you on what the law is. She will give you very clear instructions. Please, follow the law. Review the evidence. Review the instructions. And follow the law. Because I'm confident that if you do that, each of you will have at least one reasonable doubt. And your vote will be not guilty. And your vote should be not guilty. Not just because you have reasonable doubts, but because James Crumbley is not guilty. Thank you.
Thank you, Ms. Lehman. Rebuttal, prosecutor?
You know what my least favorite part of the trial is? It isn't listening to the defense argue that her client is not guilty. She has a right to do that. It isn't even listening to what I believe, and I'm going to tell you what I think is inaccurate. My least favorite part of the trial is that even when we're standing here and our criminal justice system provides for justice for victims, and my job is to advocate for them, and I'm standing up here and I'm doing that. I've been doing that all week and several weeks before, and I'll keep doing it. You know what my least favorite part is? It doesn't take away any of the suffering. It doesn't take it away. So, don't deliver a verdict thinking that it will, because it doesn't. Your job is to follow the law and use your common sense when you consider the evidence. I embrace the high burden of beyond a reasonable doubt. I believe in it wholeheartedly, devoted my whole life to it. I embrace it. It's what we use for every prosecution in this country, every single day of every year, for decades and decades and decades. That's the burden we have. And it is not, despite what the argument is always, any possible doubt. You have to be 100% sure. If you're 100% sure, we probably don't need criminal trials. And you can't be. We can't be. That doesn't make any sense, does it? We can't get inside the head of people who commit violent crimes or any crime and decide what they knew and what they wanted and if they loved their kid. I hope he did. I hope he does, by the way. I assume he does. We all do. We all love our kids. That's not my job. It's not my burden. So I embrace my burden, but I'm not going to embrace something that's just not true. Because it is not true that I have to prove, and the people of the state of Michigan have to prove, what James Crumbley knew. It is not true that the people of the state of Michigan have to prove that he knew his son was going to kill somebody. We've talked about this before. If that were the case, he'd be charged with murder. That's not my burden. That is not what I have to prove. The judge is going to instruct you what burden. It's a reasonable burden, and it's as to the elements that I have to prove. Only the elements. Beyond a reasonable doubt, using your common sense and your reason. The elements, and what are the elements? You're not going to hear that the elements of this crime are that I have to prove what he knew, what he actually knew. That's not the law, ladies and gentlemen. That is not the law. The law is I have to prove beyond a reasonable doubt what a reasonable person would do using ordinary care. That's what I have to prove. There's a couple things I have to correct. The questions defense counsel asks witnesses are not evidence. It's the answers that are evidence, and you have to decide whether that's credible. But Special Agent Brandon did not testify that it was safe. He would call that secure if an unloaded gun was stored separately. In fact, that's not what he testified. What he testified to was that it wasn't, storing the firearm or ammunition wouldn't make it secure if you had a 15-year-old who knew how to load and shoot that gun. That was his testimony. You did not hear from people at the school that they were not concerned. That was not the testimony. You did not hear that James Crumbley went home because he was trying to check on his son and he was worried. None of that happened. You heard the 911 call. You have to rely on what you heard, not the questions that were asked. Defense counsel put up a statement from the Journal about my gun and where my dad hid it. And she's urging you to find that credible. But if you do, and we argue you should find, it's all credible. You don't get to pick one statement from a journal and say he was telling the truth there. But all the stuff about how he asked his dad for help, that wasn't the truth. You have to use common sense. And I'm not going to go through every single thing that Ms. Lehman told you, because I know that you were all taking notes and you all listened to it. And I laid out, and I know you remember the testimony. But the one thing I'm just going to ask you one more time is, I embrace my burden, but you have to hold me to the law and what I actually have to prove and what the judge tells you I have to prove, which comes down to common sense and reasonableness. Let's step back. We have a person, we have a father who purchased a gun as a gift. He knows he has it. He knows how to use it. He knows he's in the house by himself after it's purchased. He gets called to the school. He gets called to the school, and the words on the paper, the drawing on the paper is of that gun. You heard Special Agent Brandon. The testimony speaks for itself, and so does the drawing. He saw the words, blood everywhere. He saw the image on the paper with the bullets and the person bleeding. He understands exactly, because the image is there and you saw it, that's exactly where those bullets landed. The thoughts won't stop. Help me. I want help, but my parents don't listen to me, so I can't get any help. And then that day, just hours before, help me. Use common sense. It doesn't make any sense to stand here and say someone had no idea that he needed help when he saw on the page, help me. It doesn't make any sense, because any reasonable person, which is the standard you have to use, using ordinary care, would know that, because it actually says, help me. The world is dead. My life is useless. Those messages you saw, that's exactly what he thought. We know what was going on because of the messages in this journal. And then we know there was a cable lock. You did not hear any testimony about who owned that gun and whether that lock was used or another lock was used. But you do know that whoever purchased that gun had to be 21 years old. You do know that. We've been telling you since this case started, it would take tragically small things to prevent these deaths. And you're hearing a lot about how to store a weapon. And the truth is, this has nothing to do with a safe storage lock, and you don't have to lock a weapon up to make it secure. There's lots of ways to make it secure. But what isn't secure is leaving it around, which we know he did with his other weapon, leaving it around, my dad left it out, LOL, I thought, why not, loaded, knowing that your ammo is right there. We know that is not secure. But let's talk about one of the ways that we can prevent access to minors. This is the murder weapon. This is the gun. We know, we presented evidence of this. I'm going to put it right on the table. This is a cable lock. This little piece of cord. This is me inserting the cable lock. We know that a cable lock was in the home. We know it was provided. This is me inserting a table up. That takes less than 10 seconds. Takes less than 10 seconds. 10 seconds. You don't have to go find it. You don't have to go buy it. It was provided. It was right there. You just watched me do it. 10 seconds of the easiest, simplest thing. One of which, by the way, not the only way. Locking was not the only way to prevent this, but it was one way, and it took less than 10 seconds. Let's talk about the gun being hidden. Let's talk about that. You heard the defendant's sister say, yeah, he went and got the gun from his bedroom. These were the other two guns. Ladies and gentlemen, the guns were kept in the bedroom. The family was there when she was told that, and everyone knew. The guns were kept in the bedroom. This is where he says he hid the gun. The armoire. This is what it looked like that day. Wet towels folded over it. It wasn't even closed. He says it was in the armoire under some jeans. This is not hiding a weapon. This is just where you kept it. It is not reasonable to conclude that a 15-year-old who spends all kinds of time in the house alone would not know where it was, because it wasn't hidden. This isn't a case where we have a parent who hides a weapon far out of reach from a child who couldn't get to it, doesn't know it exists, ammunition in a totally separate spot. The kid, that's not this case. It's reason and common sense is what we have to use. We know that James Crumbley went home and looked for a gun when he heard there was an active shooter. And we know he referenced there was that meeting at the school. That's foreseeability, and that's a person who suspects their own son. And that is what I have to prove. Foreseeability to an ordinary, a reasonable person using ordinary care. This case is not a statement about guns. It's not a statement about parental responsibility. It's not about kids doing kids things. The kids on November 30th in that building were doing kids things. Hannah, Madison, Tate, Justin, they were going to class. They were talking to their friends. They were dancing in the hallway. Those are kid things. Parenting is the hardest job that we'll ever do. The hardest job, and one of the most important ones, but it's exhilarating and joyful and the best experience of our lives. We look at our kids when they're born and we see hope. But they can break your heart. They're supposed to. They have to leave someday. They don't come with a set of instructions. I'm not here to tell you that this case is about somebody who didn't follow the instructions to be a perfect parent. But we do have a guide. We do have a basic standard for ordinary care. We all have doubts about our kids. We all worry every minute of every day that they're going to do something or something's going to happen to them, and then it might be because of something we did or we didn't do. We are not responsible for everything our kids do. This prosecution in this case is not inconsistent with that. It just isn't. This is a very egregious and rare set of facts. We do have a measuring stick, ladies and gentlemen, and it's the law. And it requires us to use ordinary care. And there is a consequence if we don't. In a very limited way that the law allows a parent to be charged. Your job now is to go back there and use your reason and common sense and follow the law. That's what your job is. You listen to all the evidence, and at the end, you will conclude that James Crumbley failed. He might love his kid, I hope he does. But stick to what I have to prove. Stick to what I have to prove. And remember that he didn't just fail in his duty to his son. He failed in his duty to protect Hannah and Justin and Madison and Tate. And I don't say their names to evoke sympathy. I say their names because they matter. They matter. And that is why we are here. We are absolutely here about what happened in that school that day. Because if James Crumbley had done even the smallest of things, like the 10-second cable lock, or gone home, or took responsibility for his kid who was in trouble, those kids wouldn't have been shot and killed in that school on that day. I have met my burden. Mr. Keast and I, the people of the state of Michigan, have met the burden to find James Crumbley guilty of 4 counts of involuntary manslaughter. And I ask you to return that verdict. Thank you.
Thank you, prosecutor. I'm now going to read jury instructions to you. Does anybody need a break before I do that? Anyone needs a break? All right. You're going to get a copy of these jury instructions in the jury room. All right? Members of the jury, evidence and arguments in this case are finished. I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and the instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any facts in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout this trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt that is based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what evidence is and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments and commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, my questions to the witnesses, are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law, and to tell you the law that applies to this case. However, when I make a comment or give you an instruction, I am not trying to influence you or influence your vote or express a personal opinion about this case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender, gender identity, or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in this case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they saw, what they thought they saw, or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. James Robert Crumbley and Jennifer Lynn Crumbley are both on trial in separate cases. The fact that they are both charged is not evidence that either one is guilty. You should only consider the evidence presented in this case. Each defendant is entitled to have his or her case decided on the evidence and the law that applies to him or her. The prosecutor needs to prove beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021 within Oakland County. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider out-of-court statements against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence that the defendant ran away and tried to hide after he was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or lawyer's representative talked to one of the witnesses. There's nothing wrong with that. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from witnesses Detective Edward Rogrowski, who has given you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about the matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether these facts are true. You should also not think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and the ammunition by his minor child. Second, in doing the act that caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Tate Meir. That is, that Tate Meir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Tate Meir's death, the defendant acted in a grossly negligent manner. In count three, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count four, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Justin Schilling. That is, that Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. In count 1, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin was directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 2, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Tate Muir. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that causes an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Tate Muir was directly caused by defendant's failure to perform this duty. That is, that Tate Muir died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 3, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Hannah St. Juliana. This legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Justin Schilling. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Justin Schilling was directly caused by the defendant's failure to perform this duty. That is, that Justin Schilling died as a result of the defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. As I explained to you earlier in my instructions, the prosecutor asserts two different theories, to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because he failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because he was grossly negligent. Those are two different theories and two different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It is not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. There may be more than one cause of death. It is not enough the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I previously indicated to you that it was my order that the shooter's name not be used during the trial. When you go to the jury room, you'll be provided with a written copy of my jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and your reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury's instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you should write a note, and you can give that note to my clerk. Possible penalties should not influence your decision. If you find the defendant guilty, it is my duty to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my clerk. It's not proper for you to talk directly with me, the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. We're going to send, you can take your notes with you, and we're going to send the exhibits in with you. I think some of them might require a computer. We'll give you that as well. If you, so we're going to send all the exhibits in. This is also one I like to tell you that you can rehear, we can replay testimony, but I think I told you this in the beginning of the trial. If you want to rehear someone's testimony, you have to rehear the entire testimony, all of the questions from both sides. That's the only way that it's fair, all right? But we can replay that in the jury room. As you discuss the case, you should think about all of my instructions together as the law you are to follow. The defendant is charged with 4 counts of involuntary manslaughter. These are separate counts, and the prosecutor is charging that the defendant committed all of them. You must consider each count separately in light of all the evidence in the case. You may find the defendant guilty of all or any one of these counts, or not guilty. I've prepared a verdict form. It's pretty self-explanatory. It lists each of the counts, and this should be filled out by your foreperson. Count 1 is involuntary manslaughter as to Madison Baldwin. You can either check the box not guilty or guilty of involuntary manslaughter as to Madison Baldwin. As to count 2, involuntary manslaughter as to Tate Meir, not guilty, or guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana. You can either check not guilty or guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. You can either check not guilty or guilty of involuntary manslaughter as to Justin Schilling. Then your foreperson should sign that. All right? I know you've been in 2 different jury rooms, so probably some of you, the first 8 of you, don't know the others. This is going to be kind of like on the show Survivor when they have the merging of the tribes, right? So we're going to put you all in one jury room. We had you in separate jury rooms just because it's much more comfortable. All right. We appreciate that you were all here the entire time. Jurors have different feelings when they're excluded from deliberations. Some people are happy, some people are not happy. I can tell you a lot of stories about, life happens, so all of your service is important. This is obviously very important and very stressful to both sides, and we couldn't conduct this jury trial without you. So we are going to exclude 3 jurors by blind draw. Okay? juror in seat 5. Juror in seat 5, you are in my jury room, I believe. Do you have any personal belongings? Okay, I'm going to ask you and the other 2 jurors that we're excluding to get your personal belongings and come back in here, all right? Juror in seat 10. You're juror in seat 10. You are in Judge Anderson's jury room, the second jury room. Do you have personal belongings in there? Okay. And you're in seat 15. All right, actually, why don't I ask the 3 of you to get your personal belongings from the jury rooms and then go with Miss Nella to my chambers. All right? So you'll go to the jury room that your belongings are in and come out into the hallway, and Miss Nella will escort you into my chambers. All right? All right. You can be seated. Okay, so do some of the jurors here, anyone 9 through 15, do you have anything in Judge Anderson's jury room? Okay, I'm gonna let these 3 jurors go into my chambers, and then anyone 9 through 15, if you have something in Judge Anderson's jury room, then you're gonna go to my jury room. All right? Okay. So I'm gonna give them a few minutes. Also, after you go back there, I'm going to ask you to wait a few minutes before you start deliberating. I want to consult with the lawyers to make sure the jury instructions are correct. Sometimes things are left out or there's mistakes, so I just want to make sure. I also want you to know that we're now on your schedule, so what you say goes. If you take a 5-minute break, an hour-long break, whatever you do, we will be waiting for you. There's potentially an opportunity to go later tonight if you want to do that. I want to encourage you to take your time. You can come back tomorrow, you can go later today, whatever you need to do. We want you to be careful, keep an open mind, and take your time. All right? So I'm going to wait and see if those 3 jurors are in my chambers. Okay. All right. Just go on. It's hot in here, right?
Yes.
We try. This is an old building. All set? All right, so if you can all get together in my jury room, I will send jury instructions in there shortly, and then you can start deliberating. You can't deliberate unless you're all there, so, all right?
All rise for the jury.
Oh, sorry. All right, you may be seated. There is one error in the jury instruction on 4.1. At the end, it talks about, and in deciding if you believe the defendant's testimony in court. So I'm just going to
Yes,
take
Judge,
it out.
thank you.
All right, anything else about the jury instruction?
Nothing other than that, Judge.
Nothing, Your Honor.
All right. You have your cell phone numbers, right?
I'll be here, Your Honor.
Okay.
We will be 5 minutes away, I promise.
I think Lee is asking for a copy of the jury instructions, which I'll provide if you both agree. If you don't, I won't.
I have no problem with that.
No objection, Your Honor.
All right. Anything else? Oh, you're gonna give me all the exhibits.
I have them here.
Okay.
We have the exhibit list with redacted portions for any exhibit that was not admitted.
Okay.
And first two.
Yeah. Yeah.
We have a judge's copy as well.
Okay,
Yeah.
all right, thank you. Yeah, thank you. Anything else about that? All right, so aside from that correction 4.1, you agree with the jury instructions?
People do, Judge.
You're okay if I send the exhibits in and they are going to start deliberating?
Yes, Your Honor, thank you.
Okay. All right. Let me make sure the doors are open.
Ms. Williams, the updated exhibit list has been emailed to me, so that's good. Okay, thank you.